Before we begin, there is, I think, one matter that I need to address, and that is Ms. Peoples. As far as the determination, I think that has to be made a factual finding as to whether or not your client actually killed Tristyn Bailey. That is typically a finding that would be made by a jury. However, because there was not a jury trial, factual finding could not be made by the jury. And I just want to make sure that there's a stipulation and agreement that the court can make that factual finding based upon the testimony and evidence that was presented during the sentencing hearing. Is that all correct?
That the court is relying on the evidence that's presented in the sentencing hearing
And
for
yes,
that factual finding.
for the court to make the factual finding. You're waiving your right to have a jury make that factual finding.
Yes, by entering the plea, Your Honor. Yes.
All right. Based on the evidence that was presented during the sentencing hearing, as well as the defendant's plea to the charge of premeditated first-degree murder, the court does find that Aiden Fucci killed Tristyn Bailey, which now makes the range of possible sentences for Mr. Fucci a minimum of 4 years in prison up to life in prison. Before I begin to address the statutory factors that the court must consider under 921.1401, let me address the Bailey family, as well as the friends who are here today and who have also been here throughout these proceedings. The loss in which you have clearly suffered is unimaginable. The court was certainly moved by the words and the victim impact statements that were presented earlier this week. I have been through these types of proceedings numerous times. Sometimes family members hope or expect that whatever the sentence is, that somehow or another that's going to heal or provide closure. And I just want to warn you that it's not. It's not how it works. No matter what sentence this court imposes today, it cannot heal you. I cannot bring her back. I cannot provide a closure to this. It may close a chapter of this, but it will not close this for you. You still have a lot of healing to do, and I certainly am not going to take the place of any of your counselors or therapists, but my advice to you is simply this. Understand that the healing process takes time, and you have to move through the stages, and you have to allow each other to move through the stages at your own pace. Comfort each other, but understand that some of you may reach different phases of this healing process sooner than others. Your daughter and your sister are obviously, her body is no longer present on this earth. However, her spirit lives on through each and every one of you. From what this court can tell, she was quite a energetic, happy child. Some of you testified to the fact that when you learned of her death, that part of you died as well. And what I would suggest is that you fill that void with her spirit and her life that certainly lives on through each and every one of you. Allow Bailey Sunday Fun Days to return to your home. Allow laughter to return to your home, because in depriving yourselves of that, frankly, you're continuing, it would continue to victimize Tristyn, because that's not what she would want. She would want that happiness and the laughter to return, and the joking between her siblings. That's what she would truly want. You have to try to let go of some of the anger that you still feel. I think that's a big part of this process for you. Mr. Bailey, I want to address something that you mentioned, and that was the process of these court proceedings. I know it's been a long 22 months for your family as well as for this community. Justice at times can move a little bit slowly for those who are thrust into it. For those of us who practice it and live it and work it every day, I assure you that there are constitutional safeguards that are in place in this country, and they're there for a very important reason. And sometimes that takes time to work through that process. And that can be frustrating, it can be agonizing at times. But we strive to make sure that we get things right the first time, and that we do things the proper way. And I appreciated your comments, and I appreciated the patience that your family and the community has shown to the court system. These attorneys have worked diligently. They have had, on both sides, they have, this is not their only case, sadly. This is the only courtroom in all of St. Johns County with over 300,000 people who now live in this community. We have one felony courtroom. So every felony, every murder, it takes place in this courtroom. And these attorneys are assigned to cases throughout this circuit. I trust and I believe that they have done a diligent job in this case. And again, I recognize that it can certainly take some time, and I appreciate the patience that you've shown, and I hope that you understand the necessity in making sure that things are done the proper way. Pursuant to Section 921.1401, the court, in determining whether a life imprisonment or a term of years equal to life imprisonment is an appropriate sentence, the court must consider the following factors. A, the nature and circumstances of the offense committed by the defendant. B, the effect of the crime on the victim's family and on the community. C, the defendant's age, maturity, intellectual capacity, and mental and emotional health at the time of the offense. D, the defendant's background, including his or her family, home, community, environment. E, the effect, if any,